my submissions are on behalf of the state of Punjab. What we have done is I'm addressing only on some constitutional aspects. To save time a lot, my friend Shadhan will address on some legislative aspects, executive aspects. So, my lord,
No.
Alright. I'll make my submission.
We have,
Anyway, whatever he has to
we
say.
have embarrassed our colleagues not to.
All right. Whatever he has to say, I'll say it.
Yes. So we are
Correct.
we
I appreciate
are let down an arm, then it
No, I did not. When we initially got the brief, we planned the work in such a way that it is not too much load on one person. But I appreciate your lordship. My lord, my submissions are now in 7 pages. They are lesser than Mr. Venugopal's, the shortest.
1 page.
By 1 page. So the shortest.
We hope that all your followers follow the same.
So I kept it to 7 pages. Now, my lord, what I've done is I've followed most of the arguments. The benefit of transcript is there. So to the extent possible, I have not made anything which has not been said earlier. My only request, suppose I'm repeating something, lordship may just stop me and I'll skip it because time is short. Now, my lord, my submissions are at page 1119, but my colleagues have been hard copies, I think.
So we already got it.
Hard copies, yes. My lord, my first submission, hard copy. Just different.
So the bigger one.
I'll just, my lord, may I start? I shouldn't take more than half an hour or maximum because just 5 headings are there, so I should finish as fast as possible.
We are going to give 1.5 hours tomorrow to you also because we are going to give 1.5 hours tomorrow also.
This side. Yes.
This side. Because the solicitor had eaten up your 1.5 hours, so we would like to compensate.
No. But this is, I would also, my lord, request that let him take whatever time it takes.
No.
Because this is not a matter where, my lord, either of us can be constrained on time. My lord, we must assist your lordship fully and, my lord, in every aspect possible.
We are giving question hearing to everyone.
Yes.
We are not rushing it.
I'm fully confident of that.
But only thing, my lord, since by the time I've come around, most of the points have been discussed, so there is no point in
Repeating
something.
them.
Yes, unless something new, my lord, there is no point in. Now, my lord, my first submission, which is in my thing is, my submission is that the governor has no discretion. He has only 3 options. His discretion is to choose one of the 3 options. And the first question referred in the presidential reference is on presidential options, governor's options. Even the question 1 and 2 in the questions refer only to the options. Now, my lord, my submission is Article 200 uses the word as soon as possible. Much has been said about it. I found that it has been used in 7 places in our constitution.
As soon as possible.
As soon as possible. As soon as maybe it's been used in Article 22(5). Actually, as soon as possible has been used in 242 statutory provisions, but most of them are as soon as possible laid before the legislature, that kind of thing. So I don't want to get into that. Where substantive as soon as possible is in 7 places. Now, my submission is, it has already been pointed out that 6 months was replaced by as soon as possible in the assembly. All that
6 weeks.
6 weeks as soon as possible. Now, why do they say as soon as possible? I'm just putting my proposition for lordship's kind consideration. Because the kinds of bills that may come before the governor may be of multiple types. There could be a simple amendment bill which doesn't require much time. It can be approved the very next day itself or the same time. On the other hand, there could be a complex bill which may involve matters falling under on list 3, which may involve a matter falling parliamentary laws already in place. So there the governor may take some more time to think. So as soon as possible doesn't mean an infinite amount of time. It depends on the context of the bill presented to the
Depending upon the facts and circumstances.
on the facts of simple amendment to some sales tax law doesn't take more than 10 minutes for him to see. Now it comes to as soon as possible means if the bill is complicated, he can take a week, 2 weeks. He may consult the
Advocate General or the other.
Yes, he may take that. He's part of the government, so he may consult the Advocate General, get an opinion or whatever. Now, my lord, my submission is to accept the stand of the union is to result in a constitutional paradox. And why I say that, Lordship will kindly see Article 200. Now the argument is that I can withhold the assent
Indefinitely.
indefinitely. And what they say is, our side has argued that withhold assent must be read with the proviso. Withhold assent is only for the time taken to prepare a message, which in my humble submission could be the only possible interpretation, because withholding is like a pause. You're pressing the pause button and saying that, look, let me look at the bill. Is there something for which the governor wants to make a recommendation? Does he want to give a message? Now, if your Lordship kindly sees the proviso to Article 200, provided that the governor may, as soon as possible after the presentation of the bill for assent, return the bill if it's not a money bill, together with a message requesting that the House will reconsider the bill or specified provision thereof. So two parts are there. He can ask the House to consider the bill in entirety,
Or part thereof.
or he may say, look, some provisions are problematic, kindly look at them. And in particular, will consider the desirability of introducing such amendments as he may recommend. So Lordship will kindly see the governor can say that, look, this particular provision is problematic. Why don't you think of this amendment? So he has got that much. So he can either reconsider the whole bill, reconsider the part bill, or he can go one step further and say, substitute clause 36 to mean something else. All that he can consider. Now, then the message goes back to the legislature. Now, please see the constitution. And when a bill is so returned with any of the three things, the House or Houses shall reconsider the bill accordingly. And if the bill is passed again by the House or Houses with or without amendment and present to the governor for assent, the governor shall not withhold assent therefrom. So whatever recommendations he made, even if they are salutary, the governor cannot withhold his assent. The paradox I'm saying is from what the union side is, if the governor applies his mind, gives a message, amend this provision or think about this provision again, and the legislature decides that yes, we still want to go ahead with it, then the governor cannot withhold the assent. Now what they say is, it will be paradoxical to say that the governor can withhold assent without making a message. But once he makes a message and the legislature does not accept it, he cannot withhold assent. Lordship appreciates the point. After application of mind by the governor, if he says, please consider this, legislature says, I still want to go ahead with it, then he cannot withhold assent. But it will be absurd or paradoxical to say that I will not make a message, but I will withhold assent. That's my submission. That's why the argument has to be rejected. Now take a concrete example, which I have also been deeply concerned with so many years. Take, for example, in Maharashtra, we have this chronic problem of reservation for Marathas. All of us know it. I have appeared 3 times in 3 rounds, again and again. Now, a bill is prepared for reservation crossing the 50% limit. The governor may say, what are you doing? Indira Sani says 50% is the limit. Para 821 only says, except in far-flung states, etc., you can't cross the 50% limit. Yet the assembly goes and says, we want to cross 50%, want to make it 16% more. Governor has no choice. Then it's for the legislature to say that because of Indira Sani, we are striking it down. But what I'm submitting is, because the Attorney General's submission also in the just Pardiawala was, he can examine the validity of the bill and make comments thereon. I'm saying, sorry, he cannot. And we got concrete example of Maharashtra. It's happened again and again. The governor cannot withhold assent. That's my submission.
According to you, like 111,
Yes,
if the president sends back the bill to the parliament,
yes,
and if it comes back as it is,
yes.
the president has no option but to
No
have
option,
assent.
no option.
The similar analogy you apply even in
Exactly,
200. That's
exactly. Because my lord, the governor is not a constitutional filter to say, all right, this is an unconstitutional provision. This is coming under list 3. If I still want to pass a law under list 1,
that according to you is exclusively reserved for the judiciary.
yes, yes. But the governor with his serious advice, he can say, please rethink. please rethink. This is the problem available to you. That's my submission. Now, my lord, kindly come to the. Now the argument is he can give the assent straight away. He can withhold assent to make a message. My humble submission is withhold message is inextricably interlinked with that message provision. It's like Siamese twins. You can't divorce withholding a message without assent. Once he withholds a message, then he has to start working and take the trouble of preparing a message. He can't have a withholding a message, withhold assent and keep it as it is. Now, the last part is reference to the president. When can you refer to the president? What has happened now in some such states is routinely bills are sent to the president. And that gets indefinitely delayed. My submission is the scope of 200, that last part of reserving it for the consideration of the president, can be read with Article 213. That is not there in my note. Lordship may just make Article 213. In fact, I thought about over the weekend, I thought about it. I had 213. Ordinance 213. Now, my lord, this ordinance power is there. If a lordship sees 213, if at any time, I read 230, if at any time, except when the legislative assembly of a state is in session or where there's a legislative council in a state, except when both houses of the legislature are in session, the governor is satisfied that circumstances exist which render it necessary for him to take immediate action, he may promulgate such ordinances as the circumstances may appear to him to require. So please pause there for a minute. The satisfaction of the governor is the satisfaction of the Council of Ministers. Sorry, may I proceed now? Yes. The satisfaction of the governor is satisfaction of the council.
Point. How much take on this point?
Me?
Yeah.
30 minutes, I'll take 30 minutes.
On this point.
On this point, just 3-4 minutes more. No, we'll have it after lunch, no problems. I have